Everyone, please go ahead and take your seats. We're going to get started now. I'm going to turn things over to Sam Lebovic, the Institute's Senior Visiting Research Scholar this year. Thank you.
Good afternoon, all. Thanks for sticking around for the full schedule. Which good decision. We've got a dream panel to wrap things up on the terrifically interesting subject of whistleblowing and free speech and democracy. So I'm just going to introduce our panelists, necessarily just selecting a tidbit of all of the many accomplishments that I could proclaim to you all. To my left, Kathleen Clark is a professor of law at Washington University, where she specializes in ethics, whistleblowing, and national security law. She's led anti-corruption and ethics workshops in a range of other countries, including Australia, Bosnia-Herzegovina, Canada, Indonesia, Japan, and more and more. And when she was working as an ethics lawyer for the DC government, she wrote the ethics manual for the city's 32,000 employees. So plenty of experience to bring to the table. To her left, we have Sarah Milov, who's an associate professor of history at the University of Virginia, where she focuses on political and legal history. She's the author of the award-winning and excellent The Cigarette, A Political History, which is a really terrific study of the kind of political economy and regulation of the cigarette industry, and is now writing a biography of nuclear whistleblower Karen Silkwood. To her left, we have Carrie DeCell, who's a senior staff attorney at Knight and lecturer in law at Columbia. Has been very involved in the Institute's litigation on freedom of speech and government surveillance, and at the forefront of the Institute's advocacy efforts against the prosecution of whistleblowers and publishers under the Espionage Act. And rounding out the panel, last and certainly not least, is Ron Krotoszynski, who's the John S. Stone, I don't know if there's another John Stone, the John S. Stone Chair of Law at the University of Alabama and Director of Program in Constitution Studies and the Initiative for Civic Engagement, has written just a huge number of law articles on administrative law, telecommunications, First Amendment, and a lot of books. The one I'm just going to plug in advance is his forthcoming Free Speech as Civic Structure, a comparative analysis of how courts and culture shape the freedom of speech, which I think is out in later this year, is that? Yes. That's in May, okay. So another book for you all to add to your summer reading list. So to begin, I just thought Kathleen could give us an overview. I've given her the impossible task of summarizing the state of whistleblowing law from 30,000 feet as efficiently and quickly as possible. Kathleen, over to you.
Great. The law of whistleblowing, and by whistleblowing I mean the disclosure of alleged wrongdoing or a danger. The law encourages whistleblowing in 5 distinct ways. First, a few laws actually impose on employees a requirement to report certain kinds of wrongdoing. For instance, there's a federal regulation that requires executive branch employees to disclose waste, fraud, and abuse and corruption. Second way the law encourages whistleblowing is that many laws actually prohibit retaliation against whistleblowers, but these laws generally have a rather limited reach. Certain sectors, for instance, in the national security sphere, almost all employees are excluded from that protection, and retaliators almost never get punished for retaliating against whistleblowers. Third, some laws promise remedies for whistleblowers who experience retaliation, remedies such as compensation or, on rare occasions, reinstatement. But judges have construed these statutes narrowly. Fourth, some laws encourage or require institutions to create mechanisms that facilitate whistleblowing. We heard about one earlier today about the State Department's dissent channel. That would be one example. Finally, there are laws that provide financial incentives to whistleblowers. One such law, the Federal False Claims Act, has been, I would argue, the most effective whistleblower law that we have, resulting in billions of dollars of recovery for the United States government. But the federal government asserts that federal employees are not eligible for those financial incentives because they already have the obligation to report fraud as employees. The primary goal of these laws, I believe, is not to protect individual rights to personal expression, but instead, I would argue, the primary goal of these laws is to promote democratic accountability through a whistleblower's disclosures. In other words, a whistleblower is a means for achieving a democratic end. And I wonder whether if lawyers on behalf of whistleblowers could somehow convince judges that the way to frame the analysis is not through individual expression, but through the public interest served by a whistleblower's disclosure. I wonder whether we would have more success in whistleblowing litigation. I'll stop there.
Okay. That's an unbelievable job of giving us a kind of big picture lay of the land. The only thing I'll add is that I think I'm correct. Most of these, with the exception of the False Claims Act, are really sort of post-Watergate.
No, actually, you're right about. Oh, sorry. So you're right that the False Claims Act has, as it's originated in 1863, sometimes referred to as Lincoln's Law, and we will hear about the early 20th century origins of federal whistleblower protection from, I think, the next.
That leads me. I've just been kicked out of moderating because that's exactly what we wanted to do. So Sarah, would you introduce us to the first whistleblowing law?
All right. If Kathleen gave you the 30,000 foot view of whistleblowing, I'm going to take you to a ground zero. So the paper I offered at the symposium yesterday offered a history or a reconstruction of a 1912 law called the Lloyd-La Follette Act, which is a lesser studied bit of civil service law. What a testament to it. This law basically did 4 things. Number 1, it said that nobody in the civil service could be removed except to promote, quote, the efficiency of service, which basically kind of nudged the civil service further away from an at-will model. Secondly, it said that if you were removed for efficiency, in the name of efficiency of service, that you had to be provided the reasons for your removal in writing, and that you had to be granted, a reasonable time to respond to those, which, implied a procedure that, which offered a procedure for a fired employee to kind of make his case publicly, to engage in an adversarial procedure against the government. Number 3, it affirmed the right of postal workers specifically to form unions. This becomes important in my story. And number 4, it said that civil servants possess the right to disclose information to Congress. And it's this last provision, which is why the Lloyd-La Follette Act has been called the first federal whistleblower law. Now, my paper explains why this law came to be written. Why did Congress need to say that civil servants need to be able to provide information to Congress? What was going on in the early 20th century? And why, for that matter, did Congress need to announce its own right to this information? Why was it asserting its own prerogative against secrecy in the civil service? So the argument I put forward in my paper is that this act represented a response by organized labor, specifically the labor of postal workers and their allies in the union movement. At this time, it was the American Federation of Labor, the AFL, to basically more than 15 years of executive, presidential, and executive branch repression that were known colloquially as gag orders. Now, these gag orders were intended to punish postal workers, but really they were extended to the entire civil service for speaking about their working conditions and organizing. And I'm going to go through some of these gag orders just to give you a sense of their flavor. They were first issued by postmaster generals, but then extended by President Roosevelt and President Taft to apply to the entire civil service. They forbade a range of speech and organizational activities like visiting Washington to engage your representative, It forbade railway mail clerks specifically from saying anything that was detrimental to, quote, the efficiency of service of the Postal Service or, quote, friendly relations with the railroads. This is important because railway mail service workers, who I should note were at the time, they constituted at the time the largest branch of the Postal Service, and they were also kind of the most prestigious because their job was very difficult. They were frequently involved in train wrecks, and train wrecks were a pretty common occurrence in the early 20th century generally, but when wrecks occurred, it was not infrequent that railway mail workers died because their cars, which were leased by the Postal Department from the railroad companies, were retrofitted baggage cars. They were wood-framed and not steel-framed as the rest of the cars, and sometimes they would be crushed in kind of an evocative report like a strawberry box. So this is, obviously a matter of working conditions, but it also was a matter of whether or not the government was being defrauded and how much it was paying for the lease of these cars. Another order forbade employees, this is the Taft order, from even responding to requests from Congress about information about the service. Any information about the service could only be provided by department heads. This kind of echoes more contemporary theories about who should be speaking to Congress on behalf of the civil service. And kind of in the most insulting instance, Taft forbade railway postal workers specifically from speaking about aforementioned train wrecks. This was known in the service as the so-called wreck gag. What my paper tries to do is to show how this assertion of executive control, which came with a weaponization of the postal bureaucracy, the post office had a whole cadre, essentially, of internal investigators, the postal inspectors, that ferreted out complaints made by postal workers. So, it was not hard to figure out who dissenters were within the railway mail service. How this actually backfired and kind of led to a radicalization of the entire postal service, but railway mail workers specifically. So what I'm trying to show is that in the early 20th century, the labor movement was politicized around the speech rights of public employees. And for people of you familiar with the history of the labor movement, this is frequently not what we think about when we think about early 20th century labor. We frequently think about repeated failures by the labor movement to achieve rights in court, but we're mostly thinking about the private sector. What I'm trying to show is that in the public sector and in the largest domain of the public sector, which at that time was the Postal Service, people were highly politicized around the labor rights and the speech rights of those workers. So, it was the organized labor movement in the form of the AFL and these dissident postal workers that really affirmed the citizenship rights of government workers and the centrality of speech to citizenship, what Kate earlier called a kind of constitutionalism from the ground up. So I think in closing that this history holds lessons for what it might mean to protect the speech rights and, as sort of was discussed earlier today, the audience rights, maybe in our own era of kind of judicial hostility to labor, and also it serves as a warning about what an empowered executive branch looks like, especially one that has decided to wage war on the bureaucracy and the knowledge contained within it.
It's terrific. We have such an image in our heads, I think, of like the individual lone citizen whistleblower, and it's such a different vision. The other thing that is terrific in the paper, I just wonder if you could give us a flavor of, is the media strategy of these postal workers to sort of get their voice out.
Yeah, I think this is an element of the story that will be interesting to talk about in the broader context of whistleblowing. But, a lot of these dissident postal workers were quite media savvy, and of course a train wreck is made to be republished in a newspaper. And actually, these dissident, one fired worker, who it's my quest to get him written into the annals of labor history, a railway mail worker named Urban Walter. He kind of self-published a newspaper, and he mailed it to the Postmaster General, who told him that his resignation had been accepted, because untendered resignation, by the way. And so that obviously doesn't silence him. It means he, there's this, now he's a full-time publisher, but his newspaper was called The Harpoon, became this like repository for grievance, anonymously sourced grievance. And it becomes a cause, like possession of the Harpoon became a cause to be fired if you were also working in the railway mail service, which I think speaks to a theme we heard earlier about what might be lurking behind government gag orders is a fear of embarrassment on the part of the state, which is precisely what the Harpoon served to achieve.
Terrific, thank you. So, part of the many things that are interesting about this story is that the two strategies that are really adopted, one is the right to take complaints to Congress, and the other is an effort to go to the media, are really kind of two distinct strategies that whistleblowers face today. The most famous whistleblowers of the last 10, 15 years tended, the ones in the public eye have been in the national security arena, so the Edward Snowdens, Thomas Drakes, Terry Alburys. And so I'm wondering if we can briefly just talk about what happens to a national security whistleblower, both when they try to go to Congress and then when they try to go public. So Kathleen, could you talk a little about how whistleblowing is supposed to work in the national security and intelligence sector and how it's actually kind of worked?
Sure. Sorry about that. Okay, so the Federal Whistleblower Protection Act that applies across most of the executive branch exempts large swaths of the national security sphere and doesn't of itself reach national security contractors, okay? So that's an important distinction. And so essentially, Congress has balked in general, I think, at the extension of certainly the same whistleblower protections that reach the rest of the executive branch to the national security sphere. However, they have instituted certain narrow protections and channels, and it's thanks, frankly, to one of those channels, what I refer to as facilitation, that ultimately resulted in the first Trump impeachment. There was an intelligence official who was aware of the perfect phone call between President Trump when he was trying to coerce President Zelensky of Ukraine, basically to do a political favor for him. And this very savvy official within the intelligence agency went to a former inspector general lawyer who was in the private practice, got advice about how to use this mechanism, which was essentially drafting a letter of concern to the inspector general, because under that mechanism, the inspector general would have an obligation to report it to Congress, okay, to the congressional intelligence committees. I think, but for the happenstance of his finding the right sophisticated lawyer, knowing about this mechanism that Congress had created, I'm not sure we ever would have found out about what he ultimately disclosed internally. He was protected from formal employment reprisal, but I would ask you to recall that many Republicans, including, I think, President Trump, but not just President Trump, vilified this individual, attempted to name him on the floor of Congress, and so, but more to the point, the protection that we generally have for executive branch employees mostly does not exist in the national security sphere.
That's great. So the perfect phone call whistleblower kind of proves that it is possible to hit the sort of billiard trick shot to kind of run the gamut.
Well said.
You'd say but you would say that's an atypical example. How do you think it more normally? What's the more normal? Say a lot of people complain that Edward Snowden, for instance, should have gone through internal channels.
Oh, yeah. Okay, so So that is one of the complaints about Edward Snowden. He should have gone internally. We have this concept that if something would be futile, we don't expect people to go through what would be a futile process. And I think there's a really strong argument that any attempt to go through the normal processes for Snowden, in my opinion, would have been futile given the state of manipulation of the law by lawyers within the executive branch regarding warrantless surveillance. That's my opinion. So the essentially, I think Snowden's decision to exile himself, right, to go outside the government, to go straight to journalists, arguably, it is an argument that whistleblower advocates put forward for why whistleblowers in the national security sector should have protection. Because perhaps if he had had protection, he would have availed himself of an internal method. That's the argument anyway. And so by depriving them of any protection, you're encouraging them to go way outside the lanes. If I could just add one thing, there's a lovely parallel between that criticism of Snowden for not going through established channels and what the early 20th and 19th century presidents were requiring, which is that postal workers, which I learned from your paper, that postal workers were allowed to go to Congress, but they had to go through the agency head, you know, and the skepticism, the doubt that an agency head would faithfully disclose to Congress complaints parallels, I think, the sense of futility regarding Snowden and internal disclosures.
So in the absence of an ability to sort of blow the whistle through these internal channels effectively, the next move, people who really feel their conscience, is to then go public. Carrie, could you talk a little bit about what happens to people in the national security arena when they blow the whistle publicly?
Yeah, I mean, basically, invariably, they spend a lot of time in jail. And that's because, as Kathleen mentioned, all of these protections for whistleblowers in other contexts, most of which are statutory protections and common law protections, don't really provide any protection against another hefty statute called the Espionage Act, which basically prohibits people within the government and then extends to people outside of the government from disclosing national defense information without authorization. And they can face many years in jail for each disclosure, and there are other parts of the Espionage Act that are more in the news today because they extend to republication or redissemination of that information by people who are outside of the government. So, you know, obviously Julian Assange comes to mind right now, but whistleblowers, and Kathleen mentioned a few, I think, and Sam has obviously focused on this issue extensively with his latest book, but you know, you can think of Daniel Ellsberg, Edward Snowden, of course, Terry Albury, Daniel Hale, Chelsea Manning. They have disclosed information that I think many of us would recognize is clearly in the public interest. But unlike the doctrinal protections that exist under the First Amendment for other public employees who want to speak out on matters of public concern. Of course, there are concerns about the extent of that protection, as I'm sure Ron will speak to in a minute. There's no opportunity under the current law for whistleblowers in the national security space to explain to the court that they disclosed information of significant public concern and use that as any kind of mitigating factor or defense in a prosecution under the Espionage Act. And Heidi Katrasser has written extensively about the need for a public interest defense, or at least consideration at sentencing, to provide greater protection for people who really do reveal, in the case of Daniel Ellsberg and the Pentagon Papers, of course, the fact that US troops were being sent abroad to die for a war that the United States government itself acknowledged it would not win, and more recently for disclosure of war crimes and other serious, kind of abuses by the US government. So that's the Espionage Act.
So there's your happy note. I mean, one of the stories that I think is being developed here is that whistleblowing as an act is one very much defined by a set of statutes and a set of very particular laws that apply different rules to different parts of the government and that have important carve-outs, and that we might think that as Kathleen's pointed to, that the key concern is a kind of general sense of public knowledge or public awareness, but actually is guided by a set of different principles around reporting particular fraud, mismanagement, waste, corruption, and then has big carve-outs for entire domains of governance. In Ron's paper that he prepared, he's imagining a very different kind of constitutional set of arguments for how we could think about the rights of public employees to dissent and blow the whistle and speak out. I'm wondering if you could give us a kind of overview of that, of how you imagine this different law of free speech in the public sector working.
Sure, thank you. And thanks to Katie and Sam and everyone associated with the Knight First Amendment Institute for putting together such a wonderful and informative and engaging program. I have lots to think about going forward, and I appreciate the opportunity to be part of the conversation. So I titled my paper in part, and someone mentioned the good, the bad, and the ugly before. Apologies to Sergio. But I view U.S. protection of whistleblowing speech under the First Amendment as deeply underwhelming and insufficient. So I do comparative law in part, not because I want to import foreign law, but rather because I think there can be wisdom in crowds, to sort of borrow Aristotle's metaphor of the feast and the politics. And if there's a better mousetrap somewhere else that would better achieve our collective goals and aspirations and better vindicate constitutional norms, including free speech norms, democratic accountability norms, we should be open to it. But I think the first part of the case I have to make is that we need a better mousetrap. Now, I think the case has been made pretty well, but just to sort of go over why I think the U.S. approach in terms of the good, the bad, and the ugly represents the ugly. The first is that the Pickering test, which has been discussed at some length in prior panels, is a kind of balancing. And the balance takes into account the autonomy interest of a citizen as a speaker and participant in democratic self-government, and the government's quite legitimate and understandable interest in managing its DMV or its Department of Revenue. And as Bob Post has written about quite lucidly and persuasively, in my view, the government, at least in some contexts, plainly has a legitimate managerial imperative for regulating what employees do. When you go to the DMV, you don't expect to be given tracts and ask what your personal relationship with Jesus is, or to have a discussion of the Mets, right? You want to get in, you want to get out, you're not looking for either sports discourse or proselytization. So if the government has no managerial legitimate interest and employees have an absolute right to speak whenever and wherever they want, the DMV experience is going to be problematic, and the quality of government services and the ability of the government to achieve its purposes will suffer. So I think Pickering is good and gets it right insofar as two of the most salient considerations in thinking about the rights of employees of the government as citizens and the government will involve their individual autonomy interest as against the interest of the government as an employer and a manager. And we just want to make sure that when the government plays that manager card, that it's doing so for legitimate reasons and not as a make-weight because it's unhappy with a citizen's participation in democratic self-government, either inside or off the clock on their own. What Pickering doesn't take express account of, though, is something that Kathleen mentioned, and that's come up before, and that's democratic accountability, and the fact that quite often to enforce democratic accountability through elections, it's essential for we the people to have information that is only in the possession of the government, and by implication in the possession of government employees. And we can sort of hope for the best and believe that government employees will embrace the role of martyr, that they'll sign up to be Joan of Arc, and will do an Edward Snowden and leave the country in order to tell us about PRISM. I think that extracts too high a cost and has a tremendous and problematic chilling effect. So I think Pickering's balance needs to encompass overtly the concept of whistleblowing speech and the collective interest we, the people of the body politic, has in information that's essential and integral to using democratic deliberation in elections to enforce government accountability. What are some of the other problems that render, I think, our current approach to whistleblowing speech by government employees problematic? Well, Garcetti comes to mind. Garcetti's been trashed. Let me trash it some more. Garcetti, as you'll recall, says that if the speech you engage in falls within the scope of your official government duties, the Pickering test doesn't apply. And so the facts of Garcetti v. Sabalas itself are problematic. Sabalas was a lawyer, and he believed that a police officer, a sheriff's deputy, was lying to obtain a warrant for a search. That's something we shouldn't want lawyers doing. Judges shouldn't want lawyers doing that. there's a public interest in that speech. But the court majority in Garcetti says because working on search warrants and submitting them to court was within his official duties for the DA's office, that Pickering didn't apply at all and he had no First Amendment claim. That obviously is going to have a profound chilling effect on the ability of employees to blow the whistle when their speech is even arguably associated with their official government duties. Waters v. Churchill problematic. If a government employer mistakenly believes an employer said something that might cause substantial disruption, they can discipline or even fire the employee. And a conic, the definition of matter of public concern for that balancing test, to get into Pickering world, to play the game, to get a seat at the table at the poker game, you've got to speak about a matter of public, not private concern. And as was mentioned earlier by David, bizarro opinions saying that if you're writing about astrophysics because that's esoteric, it's not a matter of public concern. I would argue the origins of the universe are a matter of public concern, but you can see how this plays out doctrinally with judges who don't like Carl Sagan and Cosmos enough. All right. Finally, there's one last part of the ugly that has not come up today, but I want to mention. I think it's important, and it's McKinnon v. Nashville Banner, 1995. Now, this is technically a Title VII case, but here's what it holds. If, in the context of a Title VII case, an employer acquires evidence that would justify discipline or discharge, remedies, even where racial discrimination or sex discrimination has occurred, are cut off, and no front pay or reinstatement is allowed based on the after-acquired evidence. Now, what does this have to do with whistleblowing? Ward Churchill. If a government employer has a troublesome employee and they do a fly speck of their record, they can fire them if the information would otherwise justify discharge. Now, Ward Churchill was not a whistleblower. He was the fellow who made very problematic comments about the 9/11 victims. He wasn't fired for those comments. The University of Colorado Boulder did a fly speck of all of his research and concluded he had engaged in academic dishonesty, including plagiarism. For the record, and since we have some AAUP folk here, I will note the AAUP concluded that Colorado's investigation was problematic, unpersuasive, and flawed. But the bottom line is, if you engage in whistleblowing speech, you invite your employer essentially to look at everything you've done during the course of your employment, and if they can find something in your record that would otherwise justify discharge, you're out of here. So I think all of the incentives that we have align with silence or martyrdom. And if that's the choice someone who has a mortgage to pay faces, most people, most of the time, are going to choose silence. So if we're serious about democracy and elections as a form of accountability, and as Alexander Mickeljohn says in his iconic book, Free Speech and Its Relation to Self-Government, the voters must have the information that's necessary to rendering prudent electoral decisions. And if that information is only in the hands of government employees, it's essential that we have a framework that makes it at least possible for employees to drop a dime with the New York Times or the Wall Street Journal or the local radio station about what's going wrong within that government agency. And yes, there are whistleblower protection acts, but their scope of coverage is often limited. Many of the state acts don't apply if you go to the media rather than report internally. And as Kathleen said, even if you can get the protection of the federal act, the stories, for example, with the VA and subsequent retaliation are mind-blowing and depressing. People who blow the whistle at the VA find themselves banished to basements full of black mold, and very little is done subsequently to actually vindicate the anti-retaliation provisions. They're weak and uncertain. And again, when protections are weak or uncertain, they incent silence, not speech. So we need a better mousetrap. That's argument number one. Argument number two, well, where can we find one? I'll start with the ugly, not Australia. In Australia's analog to Pickering, a case called Comcare v. Banerjee, the High Court of Australia, which is their highest constitutional court, held unanimously that the Public Service Act could be deployed to punish, even fire, an employee who worked for the Citizen and Immigration Department for making anonymous tweets that were critical of Australia's immigration policy. Now, she was not whistleblowing, right? She was not disclosing information about illegal or malfeasance or otherwise problematic government behavior. She was speaking as a citizen, criticizing Australia's immigration policies. That said, the opinion talks exclusively about the interest of a minister in responsible government and having, like GRU, loyal minions who will execute the government's policies without being subjected to criticism that might be embarrassing to the agency. And the act itself and the implementing regulations are hopelessly vague and overbroad. Doesn't matter. Here's another problem with them. They're viewpoint-based. If Ms. Banerjee had been saying, "Sisk boom ba, let's go Department of Immigration and Citizenship," she would have been given a raise and a gold star, not discharged or fired. So it's not even like our Hatch Act, which, to protect employees from coerced speech, disallows them from engaging in partisan activity one way or the other, praising or criticizing. The Australian regulations permit praising, but not criticizing. The standard of review is also one that looks a lot to me like rationality review. There's not much of an obligation on the part of the government to justify limiting employee speech or to tailor employee speech regulations narrowly. And indeed, the whole theory of responsible government is kind of incoherent as well, because if you have a change of partisan control in Australia and employees have been cheerleaders for the prior government and its minister, a new minister might well wonder whether they were doing it under coercion and to get that raise and gold star, or whether they're going to be hostile to the new minister who comes from, say, the Labour Party rather than the Liberal Party. So the Australian approach actually suggests that if you don't like Pickering, for the reasons in part that I've articulated, it could be much, much worse. What's better? What's the good? I look to Canada. Why do I look to Canada? So in Canada, there's no matter of public concern limitation to get you to the table. Employee speech regarding whatever subject matter, everything short of threats of violence or act of violence is speech under Section 2B of the Charter. All of the action occurs then at the second step of analysis under Section 1 of the Charter, which is called proportionality review. The government has an obligation to offer a pressing and substantial reason for the abridgment of the right, and the means used to achieve that pressing and substantial interest must be prescribed by law and sufficiently tailored. So in Australia, if an employee were engaged in whistleblowing speech and that information were of value to the community, that would be a relevant factor that would go into the overall matrix of analysis that would govern whether or not an employer could suspend or even fire an employee who provided information to the general public. Now, I think Australia obviously is a road we don't want to travel. I think the Canadian proportionality approach is superior to what we currently have with Pickering, but I think the essential framework of Pickering is correct. There's going to have to be a balancing test because courts are always, in any democracy, going to have to balance the managerial interests of the government against both the autonomy interests of the individual as a speaker and the collective interest in the information that animates using ballots for government accountability. I fear the Canadian approach may be too unstructured. That is to say, it is so open-ended and it lacks any sort of categorical internal rules that it may not constrain discretion sufficiently to make the decisions that result from it legitimate or consistent. And so I think at the end of the day, Pickering is probably not a bad approach, but it needs to be modified to take express account of the collective interest in the information that the public needs to hold government accountable on election day. These categorical exclusions related to matter of public concern should go out the window. I mean, what's really bizarre doctrinally is if you want to have homophobic signs outside a dead veteran's funeral, that's speech about a matter of public concern under Snyder v. Phelps. There's a different effective definition under Connick v. Myers of speech about a matter of public concern. I think speech about a matter of public concern should be the same for the DMV worker as for the crazy Westboro protester. Under current approach, it's not. So my suggestion is we need to do a better job of creating reliable, effective incentives that will permit government employees to speak truth to power and to empower us, we the people, to hold government accountable. And I don't think the Pickering framework or the statutes achieve that interest sufficiently at present. I'll stop there.
So one of the key words here is obviously whistleblowing. In 1978, passing sort of new whistleblowing protections in Congress, one of the sort of, I think, slightly bemused or surprised members of Congress said, I guess whistleblowing is now like motherhood, and we're all in favor of whistleblowing. The problem, of course, is that my whistleblower is your crank, and vice versa. So I guess my question to the panel is this: what limits would you want to put on this kind of more expansive vision of whistleblowing in the public interest? I mean, people do learn from speech from their public employees. Are there areas where there is a legitimate managerial concern? What is the managerial concern that we're balancing against? Are there places that you think it's legitimate, that it's not? Do you want to distinguish between whistleblowing of factual matters and sort of more policy dissent like the Banerjee case you talked about? Anyone can jump in.
Well, I'll just get us started. Even where an employee is subjectively blowing the whistle on what she perceives as some kind of wrongdoing, I think it is fair to impose protections for like third-party interests, like say confidentiality or privacy. Okay, so what I want to flag is the possibility of cabining or limiting protection where, or put it another way, remove from protection disclosures of information that ought to be, information that should not be disclosed. Now, obviously, I think, information that embarrasses a government official, no, that's obviously fair game, right? But, an individual's tax return, we protect that. And then, of course, the national security sector would say that that ought to be, everything that's classified ought to be excluded, and we can talk about where that line should be drawn. I just want to flag there are legitimate confidentiality concerns that should be expressed in the law, limiting whistleblower protection, for instance.
I agree with all of that, although I would note the Pentagon Papers were classified. So if classification takes the information outside completely of First Amendment, a lot of information is not going to come to the attention of we the people. So judges hate subjective rules, right? They always want to deny that they're engaged in discretionary decision-making. That's the whole reason that you see so many of our current Supreme Court justices saying it's just the Constitution and wielding it like some sort of fetish and saying that it's only the text, just the text, and then maybe augmented by the original public meaning. And of course this is a lie because the act of judging involves bringing discretion to bear to facts and law. So with respect to things like tax returns or confidential medical information, I would agree with you that a court in assessing the appropriateness of constitutional protection for non-consensual disclosure of that information should probably have a much higher burden of justification. But I'm very reticent about saying if it relates to military or national security affairs, that's an automatic win for the government, because all that will do is result in the government stamping everything within its sight with a top secret or classified designation. And there's also a number of problems that have to be worked out, like pretextual whistleblowing. What if someone has been engaged, shirking on the job, selling drugs out of the office, and they're on their way out, and they drop a dime on information that's of marginal utility in hopes of creating a defense if they're fired for good cause. So, this is complicated, right? But it does seem to me that in defining what I have in mind as whistleblowing speech under Connick Pickering, that judges should be particularly reticent to withhold First Amendment protection where information is critically important to holding government accountable, particularly for wrongdoing or malfeasance, and where that information is also highly unlikely to come to light in the absence of whistleblowing speech. So necessity would be something I would put into the test, as well as salience or relevance. And just to give you an example, to use Australia, another example, Scott Morrison, their prior prime minister, double assigned, I believe, 5 cabinet agency portfolios to himself, as well as to the person identified to the public as the relevant minister. This came out after he left office, and the current prime minister, Albanese, has said it makes a mockery of responsible government, because how does Parliament seek accountability from someone exercising government authority when it doesn't know the person is exercising government authority? And I think the current PM has it right. So the only way that would have come out prior to the change of government would have been if someone working for the prime minister dropped a dime with the media, which didn't happen. That's not good. Another example, Francois Mitterrand was very sick. He had terminal cancer. That was withheld from the French people until after he died, a few months after he left government. That's not good. So, I would say in general, right, that confidential medical information ought to be held confidential, but if you have nuclear weapons and you're on serious chemotherapy drugs and you're very sick, that's probably something the public should know in ascertaining and judging the probity and the wisdom of your actions as president of the French Republic. So I think it's very complicated and very context specific, and that then flows back into proportionality analysis rather than categorical rules. I don't see how you get these cases right and make the right balance going forward unless you take context very carefully into account. And the categorical system that we have below Pickering itself doesn't allow for context to be taken into account at all.
I guess I just want to co-sign Ron's suggestion that a contextual case-by-case analysis is, the right approach here, and it's one that does allow for, just thinking back to the Espionage Act context and the disclosure of national security information, under a different kind of approach to prosecutions under the Espionage Act, the court could look to see whether any actual harm to the national security did in fact occur. And before blowing the whistle, somebody might take into account the risk that a court would disagree with their assessment about the likely harm to the national security, and that would act as a very significant deterrent in and of itself, and therefore create, I think, a kind of broader level of protection around real national security secrets that could give rise to harm. Again, to say, there are cases like Near v. Minnesota from way, way back when that talk about the location of US troops during wartime. I think a lot of people would agree that that's probably something the government might reasonably want to protect, but there are ways to kind of enable the government to protect those secrets where the public interest might very well not be served through disclosure without categorical rules that subject somebody to significant jail time without any consideration of the actual harm that occurs.
Following up on Ron's rejection of categorical approaches, I want to suggest a metaphor. The crime-fraud exception to attorney-client privilege, right? We recognize that communications between lawyers and clients for the purposes of getting legal advice is generally protected, and we also recognize that there are limits to that protection where the relationship essentially is being abused by the client. And so I just point to that as sort of an example of an approach recognizing that context matters and that there are situations where information that would ordinarily be protected shouldn't be protected, where there's an overriding interest in disclosure.
So, I'm very taken by this morning Dan's argument that we should be more comfortable with disagreement, dissensus, conflict, and that we just got to get used to that as the cost of living in a democracy. I'm wondering, beyond the kind of particular objective harms, fields like disclosing privacy or real, genuine national security information, if there are areas in administrative governance or in the public sector more generally where there is a benefit to providing privacy, the ability to debate in private. The Freedom of Information Act has an exemption, for instance, for internal deliberations, that it says we don't want to disclose this information to encourage more robust debate internally. I think one of the examples I'm thinking of here is, the Surgeon General's report on cigarettes released in the 60s, was kept confidential, I believe, in certain ways, as to be able to be sort of launched with the stamp of kind of objective, consensual science. Luckily, we have in the room someone who can tell me what I'm getting wrong about that story. So, is that a case, Sarah, you think, where if someone had wanted to blow the whistle on what they thought was sort of biased science happening in that space, it would have been useful to democracy, or was there a benefit to kind of keeping that close to the vest?
Well, the story of the 1964 Surgeon General's report is a little bit more complicated in that, that's held up, much like I'm thinking about Ellen's invocation of the high point of academic freedom came out of the Cold War university, kind of the high point of kind of faith in public health expertise in government came out of a deliberative process that was compromised. The Tobacco Institute, the actual big tobacco, was given a kind of veto power over who got to be in the room in the first place. And on the one hand, you can imagine today a whistleblower saying, hey, it's not fair that the Tobacco Institute got to, veto so-and-so from Harvard who is going to come to a conclusion that they didn't like. But of course, on the other hand, the result of that process, which was truly deliberative insofar as people changed their minds, half of the room stopped smoking, ended up redounding to the benefit of government and the public health. It took a longer time than it would have if there had been 12 people in the room who all agreed, because the science was already settled.
Yeah, so I'm thinking of this in the context of environmental regulations, public health regulations. So you think what do you think? We could have lived through more disclosure coming out of that process without harm to that report?
I think if we had had disclosure earlier about the compromise of the process, we may have had a more robust conversation about the way in which big tobacco was influencing a lot of decision-making behind the scenes. Now, it remains, it's unclear how people may have thought about big tobacco, but, it took 30 years of 30 years and a whistleblower for us to even have that information in the first place.
Great. So, speaking of the whistleblower, I guess one of the questions for the panel, I don't know if you have thoughts, are there lessons for the public sector that we can take from whistleblowing protections in kind of the corporate sector or some of the other classic cases, or, what any wrong paths, right paths, ways of thinking about who whistleblowers are and are not?
Ron, you might actually be interested in looking at I'm going to get the name of the statute wrong, but essentially the UK's whistleblower statute, Public Interest Disclosure Act, I think it's PIDA, because it takes a kind of, at least from my outsider perspective, balance. It kind of is reminiscent of the way you described Canada's legal analysis under its Charter of Rights. That is, there's more of a spectrum, and so, like, if someone decides to go outside the normal internal whistleblowing, they have to have justification. More justification than they would have to have for going through internal channels, for example, right? And so it's not about constitutional analysis, it's statutory analysis, but I think that it's that kind of balancing or proportionality I think it parallels in some way what you were describing going on in Canada.
I will do that. That's a great suggestion. And I think some of the factors that Pickering does not necessarily require a district court judge to apply, but which should be part of the metric, are the collective interest in the information overtly above the line. That should be, there's a third-party interest with respect to at least some government employee speech, which is disclosing truthful information about misconduct by the government. I don't mean policy disagreement, I mean overt, irrefutable misconduct. And second, the social value of the speech, right? I mentioned earlier, one of the things I've thought might logically be part of the analysis would be the probability of the information coming to light through alternative channels. Where the information is almost certain not to come to light through alternative channels, then the social value of the whistleblowing speech is quite high. If it's already been published in the New York Times, then the need for the employee to drop the dime seems less self-evident. And with respect to national security, I just want to circle back to that. Recall that during George W. Bush's presidency, we had extraordinary rendition to black sites in Poland and Romania where there were credible allegations that our government was torturing people. All right? I think I want to know about that when I vote in the 2004 election. If my government is using black ops to torture people in foreign countries, that's something that I want to take into account when I decide who I'm voting for president or Congress. And I don't think that information can come out unless somebody violates the Espionage Act. It just can't, right? So the Espionage Act can't be an absolute trump to the First Amendment any more than Alabama's law of tort was an absolute trump to the First Amendment in New York Times Company v. Sullivan, right? The fact that a law relates to national security shouldn't switch off the First Amendment free speech clause as if it were the ignition to a car. So I think we have to figure out what the social value of speech is and the necessity of the government employee being the one who provides that information. And I realize this is a hard task. And I also realize when you talk about social value of speech, I'm surprised the hand hasn't shot up and said, you're talking about judges engaged in content-based regulation of speech, because I sure as hell am. To which I say, political speech is more protected than commercial speech. Commercial speech is more protected than sexually explicit speech. The whole fabric of First Amendment jurisprudence is shot through with content-based distinctions that reflect judicial analysis and appreciation of the social importance and social value of speech. If you can use that to build out a system of free speech jurisprudence that distinguishes plausibly between core political speech, artistic and literary speech, commercial speech, and sexually explicit speech, Why can't you do it in the context of employee speech? You can, you just have to be a little more diligent, a little less lazy, and realize that you're going to be criticized by some people who don't agree with how you apply the decision. But Ronald Dworkin says, and I think he's right, that the coin of the realm for judicial decision-making, which distinguishes judges from politicians, is a duty to give reasons, principled reasons, reasons a judge believes, and to then stick by those reasons going forward. Fred Schauer says similar things. And I think judges are capable of this. I really do. The question is whether our Supreme Court cares whether voters have the information they need in order to hold the government accountable through ballots. I think the jury is still out on that question.
I want to bring out the rest of the panel on exactly this question, but just a reminder, if you want to send questions via the QR code, or we'll take a few questions from the floor in a minute if people have them. I mean, it is striking, that a lot of the previous panels have talked about skepticism about the judges, concerns about kind of vague rules for employees about what's public speech and what's not appropriate speech. And this is a kind of framework where we're sort of asking individual employees to think to themselves, is this something that the public has a right to know? And then to take the risk involved, and then to ask judges to sort of deliberate. You've made a good case for why you feel, that that's an okay way to handle the situation. I'm wondering what the rest of the panel feels. Prefer other methods, statutory methods?
I'll just say that that kind of calculus is labeled as, got Snowden labeled as arrogant. And some people criticize that kind of, democratic self-help as anti-democratic because it should be the elected officials who are determining our policy rather than, we can't rely, it would be dangerous to rely on lower level officials to make determinations of what is in the public interest to disclose. Anyway, I want to channel that criticism because it's quite prominent.
I'll just add to this that this earlier history is a history in which people were grappling with a court that was as hostile to labor rights as any. This is the Lochner era, and they sought, they spoke a language of constitutionalism and free speech before there was a recognition of public employee free speech rights, and postal workers did that because they were buttressed by a labor movement that was also doing that and saw free speech as a precondition to and a result of labor organizing. So I would take issue with framing the action of whistleblowing as an individual act or an act of conscience because, at least in this story, blowing the whistle on a train wreck was, or, the government overpaying for shoddy facilities that were, killing railway mail workers was a matter of private interest that also implicated the public, and it was thought of as contiguous with a labor right.
I want to plug the new book, and I see an opportunity. I wish I had brought cards. I should have taken a page from my colleague here. But here's the argument I would make in response to Kathleen's point. When politicians regulate speech, incumbent politicians, they do so from a position that involves an inherent conflict of interest. What does a member of Congress most want? They want to be reelected. So when an incumbent politician adopts a speech regulation, even if they label it a national security regulation, we need judges to fly-spec that. Now again, judges can be political and corrupt too, but they don't have an electoral necessity or interest in the way, a direct one anyway, a personal one in the way elections are conducted. And in fact, in Israel and in Australia, which both Israel lacks a formal written constitution, Australia has one, but it doesn't have a free speech guarantee. The highest courts in both places have conjured one from provisions in the Australian Constitution that guarantee voting as a means of securing democratic ability, and from the 1948 Declaration of Independence in Israel, declaring Israel to be a democratic polity. And both courts say you can't have democracy without free speech. Free speech is an integral component of free and fair elections. We're committed to free and fair elections, therefore we have democracy. And so if you believe in that inexorable relationship, that free speech is essential to democracy, it kind of follows on, and this goes to the right to education that was talked about earlier, that citizens have to have both the cognitive ability and the skill sets, media literacy, constitutional literacy, and the information, the operative information, to use their votes rationally to enforce government accountability. But I had a question for Kathleen. You've represented clients, and when they come to you and say, hey, here's this horrible information, can I call the New York Times? How do you currently advise them under the Connick-Pickering approach? And if the approach that I've advocated were in fact to become the law, would you feel more comfortable in counseling them that if they go forward, they're not necessarily going to be Joan of Arc and turned into a schmore?
Well, I'm not going to base this on my own lawyering, but I will tell you that I used to be on the board of the Government Accountability Project, a whistleblower organization that's existed since a little bit after Watergate. And they routinely advise their whistleblower clients about the parade of horribles that is going to happen to them, likely, and basically in an effort, if not to dissuade them from blowing the whistle, then ensuring that there are no surprises for them. And I actually believe that it probably won't matter much what the legal standard is, because they're going to be screwed, okay? No matter what the law says, they will probably be screwed. And that's why, I just want to come, this is why, in my view, the most effective whistleblower law on the books is the False Claims Act that provides really huge financial incentive to blow the whistle on fraud that has been committed against the government. And here's the thing, it's not, there's a whistleblower protection compensation provision of the False Claims Act, but that's not significant because that only compensates you like for the loss of your job. But what happens is whistleblowers lose their careers. And so the financial incentives have to be calibrated to acknowledge the gravity of the loss that is likely to occur, even with the best protections. So I guess in that way, I'm, I guess, a little cynical about how effective law can be. Although, again, I actually, you know, the Ukraine intelligence whistleblower is an example of someone who, you know, got excellent legal advice and didn't suffer professionally as far as we know. But certainly suffered from derision and criticism publicly, vilification, really.
So Kathleen, can I ask you to elaborate just a little more on how the False Claims Act works and what the incentives are?
Okay, so during the Civil War, the Union government was purchasing lots of material and was getting defrauded a lot. And so in response, the Congress passed this False Claims Act, which empowered individuals to sue in the name of the United States government and get a portion of the proceeds if the fraud was proved. There can be, I think, treble damages under the False Claims Act. And here's the real key. The person who, the whistleblower, they're called relators, can be awarded up to 30% of the proceeds, either the settlement or the verdict, as well as attorney's fees. And so there has developed a plaintiff's whistleblower False Claims Act bar that has developed expertise and is quite skillful in bringing these lawsuits. And there are single cases that have resulted in billion-dollar settlements. The largest cases have involved Medicare and Medicaid fraud because the federal government is so involved in healthcare reimbursements. There's a long and sort of arcane process for bringing these lawsuits in the name of the government. And there are people who, some scholars, certainly certain judges or justices, who believe that this statute is unconstitutional because it delegates to individuals the ability to act on behalf of the executive branch, which is anathema because it interferes with basically presidential power and presidential control. Anyway, that's my thumbnail sketch.
Beautiful, thank you. I mean, one other thing that this raises is how much of our whistleblowing law is reactive. I mean, it's about preventing harms. are there other models apart from the False Claims Act for incentivizing these kind of disclosures, for requiring these kind of disclosure, for sort of affirmative disclosure as a model for government information?
Yes, there are. Like I say, there are a few examples where people are obligated to blow the whistle. I'm not actually sure how effective they are. Although, like I think it's called the Clery Act, requiring higher educational institutions to report like crime that occurs on their campuses might be an example of a required disclosure. In addition to the False Claims Act, Dodd-Frank enabled the Securities and Exchange Commission and the Commodities Future Trading Commission, the CFTC, to, through a different process, through an administrative process, provide significant financial incentives for people to come to those agencies with information about financial frauds. And within the last couple of months, the Justice Department announced a new whistleblower financial incentive in financial fraud that would be broader than that, although the exact scope of it, I can't tell you. I'll add a couple of things. The IRS has a whistleblower financial incentive program, much criticized because of lack of clarity on, what the standards are and long delays in getting awards. And some states have False Claims Act cases as well. False Claims Act statutes as well. Anyway.
I actually had a question for Kathleen that your question, Sam, provoked, and I've been thinking about this a little as we've sat here. We've been talking exclusively about the government, and I'm thinking about the Facebook whistleblower who came forward and indicated that the social media company was feeding fairly toxic information flows to teenage girls that triggered suicidal ideation and negative body image. Are there any statutes, state or federal, that would protect a non-government worker, that is to say where the First Amendment doesn't apply, where they step forward with information to try to advance accountability for private bad behavior?
Oh, absolutely. So the SEC and the CFTC whistleblowers financial incentives apply with regard to private sector fraud, right? That Facebook whistleblower hired the same lawyer as the Ukraine whistleblower. Good move on her part. There are hundreds of statutes, and many of them provide little silos of protection, or purport to provide little silos of protection for blowing the whistle on this kind of water pollution, or this type of fraud. That's the way we protect private sector whistleblowing in this country, is through many silos of protection and it's very patchy and there are gaps in the coverage. That's in contrast to the UK Public Interest Disclosure Act, which isn't focused primarily on the government, applies in the private sector, and that has a lot to recommend it, a sort of a broad swath of a protection rather than these narrow, Congress is passing a law on, some type, I don't know, the firing or the, protection of poultry, and then it'll add on a, protection for whistleblowers in the poultry industry or something like that. So I think a much better approach is to provide a broad swath of protection.
It sounds a lot like European privacy law under the GDPR versus U.S. privacy law. U.S. privacy law at the federal level can charitably be described as a Swiss cheese, which is what you're describing for private whistleblowing. The GDPR is a comprehensive, integrated regulation that protects personal data across the board. It sounds like we need a GDPR type approach not only for privacy but for whistleblowing too.
I mean, very quickly as we close, we have one question on the chat which is actually asking a little bit more about how this privacy protection works, or is it the same as a national security classification protection? Like if the government says privacy, is that it, or how does the privacy claim work in the whistleblowing arena?
It's a very good, it's a completely reasonable question. So, you know what, I'm having a hard time coming up with an explanation. I mean, I guess what I think is true is that there isn't like I don't know that there's a categorical exclusion the way there is in the national security sphere, essentially. And whistleblowers, I think, would be susceptible to claims against them for violating privacy. And if I can I add one other thing? Defendants in whistleblower litigation routinely refer to whistleblowers as disgruntled employees and try to assail them for their bad motives. And I think that motives are irrelevant. It's totally relevant in their relationship with their higher power, but I think it's completely irrelevant or nearly irrelevant in relation to the public interest. And so the idea of tarring someone with having a bad motive, that they were selfish, I just think that again gets away from what ought to be the central focus, whether or not they were serving the public interest in making their disclosure. That, I think, is the touchstone.
And a lovely note to finish on. Thank you all very much for a terrific conversation. So I don't want to stand between you and the weekend, but I feel like, and I certainly don't want to put on myself the obligation of in 3 minutes summarizing what to me was an incredibly productive and generative set of conversations. I think 3 things that I'm thinking about, that I will continue to think about, that I would love people's thoughts on if they happen to have them. The first is that one of the gambits of this symposium was to think about public employees as a category and to try to think across the different domains. I think that's very interesting and generative. I think one of the things I really enjoyed about the papers, many of them, is, in the presentations, Teague's presentation and Sarah's work on the postal workers, and is to de-exceptionalize the public sector employee. I think we've got it in our heads that there's regular citizens and then there's these public employees out there that are a different kind of beast. Bureaucracy, the bureaucrat is like a dirty word in American politics on all sides. And so it's kind of productive, I think, to think about this class of people as centrally involved in general citizenship and in general governance. Having said that, I am also thinking after today about whether it's too broad a category, and one of the things that's developing is how much we need different kind of rules about speech and behavior in quite particular institutions that are all set up to do very different things. And it may be a more productive way to approach the question is to think about what is the governance institution here, what is it supposed to be doing, and what particular rules should apply, leaving to one side individual citizen rights, to speech David's comments about distinguishing between academic freedom rights and free speech rights, I think, is kind of generative and productive. The second is, and this may get me permanently barred from the Knight Institute, is the reminder that Emerson brought up how much, the First Amendment is not the only tool in the toolbox. One of the other things I notice across particularly the union cases and the presence of Janus is that some of the things that we also need to do are clear out undemocratic uses of First Amendment law in this arena. One of the things that the First Amendment has become weaponized as is a kind of anti-governance, anti-regulatory state, sort of Lochnerized tool. And I think there are some useful guideposts through the papers today that, Carolyn's paper, for instance, to give us some places to say you could say that this kind of speech is a free speech claim, but it's not a democracy-enhancing free speech claim. And we might therefore really double down on those free speech claims that are about public knowledge, that are about self-governance, and that sort of tamp down the self-expression, my rights don't care about your feelings type of First Amendment jurisprudence we've seen a lot of. And then the final, if I can just wear my historian's hat for a second, is I've been very struck by a lot of talk about what the law is and what the rights currently are. And firstly, I'm always kind of amazed when you get down and talk to a bunch of people who really know the law, how well we do as a society when we're not really sure what the law is. Like, we kind of muddle through pretty effectively in spaces that are grey. But the other thing is that these rights rise, fall, and mutate over time in really interesting ways. And that, litigation is one of the key places that happens, but it's like the tip of the spear. And as we saw in Sarah's paper and Kate's work, and a lot of other papers across the day, Derek talking more broadly about the longer history of sort of struggles over education, the litigation is going to be successful or unsuccessful on the grounds of what other kind of coalitions are mobilized behind it and what other kind of work is being done. So I guess this is to double down on something that Ellen really emphasized. Academic freedom cases are one part of the issue, but the broader struggle to kind of create more democratic institutions within which that speech happens, I think, is important. And that, from the point of view of history, you sort of need both the sort of technical, legal litigation strategy and the broader democratic social mobilization, and those two things need to go hand in hand to create the kind of democracy and public sphere that we want. And so if today's conversation has been at all a kind of helpful brick in building those kind of coalitional structures, then that would be terrific. I just want to thank Knight for having me and for helping put this on, and for all of you for giving up a Friday, and I look forward to more conversations.
Thank you, Sam. Thank you all for being here, and for those of you who watched online, the papers we've been discussing today will be published on the Knight Institute website later this year, and the recordings from today will be up on our website shortly. May this be the only earthquake symposium any of us ever attend. Have a wonderful weekend.